We'll go on the record. State of Idaho versus Trouette, 2825-6392. All the parties are present. The argument of the parties in determining the admissibility of defendant's Exhibit A, proposed Exhibit A, conditioned on the appropriate foundation or authentication of the document or proposed exhibit. The court has already previously in argument determined that the proposed Exhibit A is relevant. Specifically, that the state opened the door by directly eliciting testimony, directly and implicitly producing testimony from witnesses implicating that the sheriff was not acting lawfully or pursuant to statutorily enumerated duties, his statutorily enumerated duties. In order for the jury to consider the affirmative defense, they're required to consider whether the sheriff was acting in the capacity of one of his enumerated duties, statutorily enumerated duties, in determining if the conduct was lawful here. And only then can the jurors determine whether or not the sheriff then commanded the aid of the defendant in execution of one of the sheriff's enumerated statutory duties. And the implication that the sheriff did not have authority or acted outside of that lawful ability to keep the peace, the other areas of inquiry on cross-examination, remains the case. The state robustly cross-examined Sheriff Norris relating to the exercise of his duties. And so to squarely place this issue before the jury as a relevant issue. The rule itself, and by the rule specifically addressing Rule of Evidence 803, sub 8, contemplates the admission of just these types of documents. I've already made the record as it relates to the reasons why that is true. The court further considered the argument of prejudice here. And as I understand the argument, it is that the assertion that the state was not on notice. There is the issue of confusing the jury, as well as fundamentally changing the nature of the trial by introducing facts asserted in the investigation, the AG's investigation. I've considered Rule 403, specifically that the court may exclude relevant evidence if its probative value is substantially outweighed by the danger of one or more of the following: unfair prejudice. Here the articulation is that this is unfairly prejudicial because there is essentially an element of surprise. And the court is required to balance the nature of the undisclosed evidence against the remedy. And the remedy being sought here isn't just simply, well, judge, just redact some portions. It is exclude this evidence, which is the most significant and most disfavored method of addressing a failure to timely disclose. This is not surprise evidence in that it was in the possession of the state for over a month. The state indicated it was aware of the existence of this document for some period of time. And so it's not a surprise. And again, the request here is to, as a sanction for the untimely disclosure, to exclude. And that is a sanction that is reserved for the most egregious untimely disclosures. And here again, this is not a matter of evidence being withheld and sprung last minute. This was evidence that was in possession of the parties for some period of time, or the parties were aware for some period of time. And so the court is declining to exclude the evidence because somehow the state is surprised at this time or is going to have to alter its presentation of its case, given the nature of this evidence. I provided the state ample opportunity to explain in what specific ways that would change, and just simply the assertion has remained that it will just fundamentally change the trial. Would note that at some point the state did indicate that Chief Haley would dispute certain findings of the report and certainly would be able to do that in rebuttal. The second area was the prejudice associated with confusing the issues. To back up a little bit, unfair prejudice. This is unfairly prejudicial. And given the probative value, and I do find this is relevant, I don't find that it has been rendered moot. The reasonable inference or reasonable view of the evidence here, in light of the videos and the testimony of Sheriff Norris, was that there was a command, and this is still being charged as an aiding and abetting theory. And so at least as it relates to one of the complaining witnesses with the aiding and abetting theory, there is a reasonable view of the evidence that upon commanding certain of these security guards, that others acting in concert were behaving in command or executing commands of the sheriff. And so not collateral. It still remains relevant. There is high relevancy to the exhibit and not unfairly prejudicial. The other argument was that the defendant's exhibit, proposed exhibit A, should be excluded for confusing the jury. And again, not explaining exactly how this proposed exhibit would confuse the jury. Certainly there are legal opinions. Certainly those legal opinions are squarely in the purview of the jury, and we had a discussion early this morning as it related to the court's concern that there are legal opinions expressed, conclusions of law expressed in defendant's proposed exhibit A, and the court indicated that that alone wouldn't necessitate exclusion of the exhibit, rather suggested three ways of addressing it. Exclusion is one, which the court is not willing to do given the high probative value of the evidence. Redaction, which neither party has proposed redaction. And so that just simply leaves the court with a curative instruction. And the reviewing courts. Mr. Hunter, I do not appreciate being interrupted.
Sorry, the court is making us out.
I understand. That leaves as a third mechanism a curative instruction. And the court indicated that a curative instruction could be appropriate. Reviewing courts have repeatedly indicated that curative instructions are sufficient to address concerns relating to topics addressed in opinions or factual investigations that tend to invade, in some respect, the province of the jury. And the court would propose that if we were going to give a curative instruction, it would essentially indicate to the jurors that defendant's exhibit A, proposed exhibit A, is not to be received as a comment on the law, not to be relied upon by the jurors for any proposition of law. Rather, the jurors are to follow the court's instructions on the law only. And the jurors are to give Exhibit A the weight they deem it entitled, if any, the weight, if any, they deem it entitled. And so for those reasons, the court is finding that, just given again, that just a bare assertion that this is confusing because of the legal opinions expressed in defendants A, that it has become moot, no longer relevant. I do find it is relevant. I do find that the relevant and probative value of the evidence is not outweighed by the danger of unfair prejudice, confusing the issues, or misleading the jury. The jury can be properly instructed on what they're to do with this evidence, and which is to consider it as they would any other piece of evidence, including testimony. And again, is squarely the type of evidence that's contemplated as admissible in 803.8. And that will be the ruling of the court. And if you want to hand up to me a proposed redacted exhibit, I'm happy to hear it, happy to look at it, but I'm not going to entertain back and forth at this time. Again, there have been ample opportunities to discuss this, to propose alternatives, to create curative instructions, to problem solve, and the court's invitation to do that has been declined. And so I would decline to engage in further conversation. You can hand up to me proposed redacted copy if you wish for my review, but I'm not going to delay the jury.
Can I request a point of clarification?
Yes.
My understanding when we looked through it was that there was an argument. So it's my misunderstanding that we were actually going to discuss this further based on developments in the case. I was mistaken in that. I have additional arguments to make. I would. I know the court's not going to entertain it, but just for the record, to preserve it in case of future appeals.
Mr. Hunter, I gave the parties no limitation on argument before we broke for lunch. I said, I will hear argument. I heard argument. I didn't interrupt you. I didn't limit your ability to argue. I told the parties I would take it under advisement and I would issue my decision, and that is what I have done. Any other issues to address before we bring our jury down? Mr. Henderson.
Just the timing matter, Judge. For the court's information, Mr. Riedel has been in touch with the Attorney General's office, specifically with Jeff Nye, the Deputy Attorney General, Chief of the Criminal Law Division. His legal staff is emailing my office that certified copy. I would request to, similarly to the state's case, go slightly out of order and call my client next to the stand and then recall Sheriff Norris once that document has been brought down to the courthouse.
Any objection to taking the witnesses out of order here, Mr. Hunter?
Yes, sir. On all the reasons that you said before.
All right. I think that there's been some latitude provided to allow witnesses being taken out of order to address schedules. I think it's appropriate, and the court is empowered to do so under Idaho Rule 611. So you may take those witnesses out of order. No objection. You may call your next witness.
The jury.
Oh, yes, I'm sorry. Ready to bring our jurors back in?
Yes.
Okay.
All rise for the jury.
Please have a seat. For the record, jurors are present, properly seated, parties are all present. Would like the jurors to notice 101, which is a minute past 1 o'clock. Wait for these guys back to lunch.